Mr. Adams.
I will second. Now I turn to fiduciary obligations. The starting point that is if a person entrusts any part of their business and affairs to another, then they cannot know what has been done on their behalf or left undone unless that other person keeps records which they can inspect and or provides them with the necessary information, either proffered or in answer to questions as to what has in fact been done. Both courts of law and equity have therefore required persons in such a relationship to account for their dealings on behalf of their principal. Courts of law did not develop effective remedies for holding agents to account, and the courts of equity effectively arrogated to themselves, to borrow Lord Dunedin's words in the partnership case of Hugh Stevenson and Carlton Nagan, the supervision of such relationships. Enforcing by injunction the principal's right of access to the agent's books and records and to information about their business and affairs, and taking an account applying equitable principles. That means throwing the burden of proof on the agent to rebut the presumption that everything they did within the scope of their agency was for the benefit of their principal, including any profit or advantage obtained by reason of their agency, thereby leaving it to the agent to justify any personal benefit by proving that they had their principal's free and informed consent to that benefit. This, in its origin, is an estoppel rule, as an agent cannot conscionably claim any such benefit for himself. And my lord, if you turn up Bousted, tab 1 authorities bundle at page 39, and go to Bousted at 6110. This is concerned with an agent in possession of his principal's property. And the first statement of principle is that where an agent is in possession of property in the agent's capacity as such, the agent is stopped from asserting a better title to it than the principal, for the agent's possession is deemed to be that of the principal. And there's over the page in 611, there is a quotation from a 1850 case, Attorney General Corporation of London. And this is about adverse possession, but it applies generally. An agent cannot well get an adverse title unless he can very distinctly show that what he has done in respect of title is in respect of title and not in respect of his agency. So he has got to prove that what he has done is nothing to do with his agency. One then and he will be stopped not from just denying his principal's equitable title, but he will also be stopped from denying his principal's legal title. If one then goes to FHR European Ventures, tab 37, one finds the modern expression of that rule.
So where are we going now?
Tab 37, paragraph 5. And if your lordships read from 5 to 7, because it covers very familiar grounds, but it's Lord Newberger in the Supreme Court. It was a bribe case, but the facts of which are really not relevant. But this is a pithy statement of principle. Well, the point I particularly rely on is at the end of 7, the centrally relevant point for present purposes, and we say for our purposes, is that where an agent acquires a benefit which came to his notice as a result of his fiduciary position or pursuant to an opportunity which results from his fiduciary position, the equitable rule, quotes the rule, that he is to be treated as having acquired the benefit on behalf of his principal, so that it is beneficially owned by the principal. And in those circumstances, the principal has a proprietary remedy. And my lord, the principle rests on the no conflict principle. And if one goes to Authorities Bundle 2 and Mothew, and the classic statement, tab 31, page 738. And my lord, there's the sideline passage where it's explained that the fundamental obligation is the obligation of loyalty. Fiduciary must act in good faith. He must not make a profit out of his trust. He must not place himself in a position where his duty and his interest, and I emphasize the word may conflict. He may not act for his own benefit or the benefit of a third person without the informed consent of his principal. And those are the defining characteristics of fiduciary. I also rely on the passage over the page, from the bottom of from 18H over to 19D, and in particular the passage at 19D, which emphasizes that even if the equitable duties of complete loyalty are modified by contract, so that the agent has the principal's consent to take into account other interests, as Lord Justice Millett says, even if a fiduciary is properly acting for two principals with potentially conflicting interests, he must act in good faith in the interests of each, and must not act with the intention of furthering the interests of one principal to the prejudice of the other. And he must not allow the performance of his obligations to one principal to be influenced by his relationship with the other. He must serve each as faithfully and loyally as if he was his only principal. That, of course, works while the interests are aligned. It causes difficulties if they diverge. And each principal is entitled to the absolute loyalty of his agent. What he has to avoid is what might conflict, can also be found in the language of the well-known passage in Al-Nahayim, which is now often cited. That's tab 40, page 989. Paragraph 159, or Justice Leggett cites Matthew. And last sentence.
Sorry, which paragraph?
Sorry, 159, 989, it's sideline. Internal 267. To promote such decision-making, fiduciaries are required to act openly and honestly, and must not, without the informed consent of their principal, place themselves in a position where their own interests or their duty to another party may conflict with their duty to pursue the interests of their principal. They are also liable to account for any part obtained for themselves as a result of their position. And my lord, what is meant by may is spelled out in Mr. Justice Mason's influential but dissenting judgment in Hospital Products, which is at tab 28 in the second bundle. Only the judgment of, I've only included the judgment of Justice Mason in the bundle. And I think the paragraph numbering differs to some extent. That used by used in some of the cases, and indeed in the passage that was cited by the judge in this case, in his judgment. What I particularly that's the passage cited by the judge in this case is paragraph 70 on page 616. That's sidelined. Passage I particularly rely on is under the heading Scope of Fiduciary Duty at 84 to 85 and going on to 86. And at 86, it says the traditional view that the profit rule is merely a corollary of the conflict rule may be traced back to the speech of Lord Herschel and Bray and Ford. It's being criticised. But he says, accordingly, the fiduciary's duty may be more accurately expressed by saying that he is under an obligation not to promote his personal interest by making or pursuing a gain in circumstances in which there is a conflict or a real or substantial possibility of a conflict between his personal interests and those of persons whom he is bound to protect. And so my submission, the test is a real or substantial possibility of conflict. The principles further explained and posted at 6079 to 80 was quite a long analysis, and I'll leave it to your lordships to look at it in their leisure. What it boils down to is that if an agent is to prove his entitlement to a benefit he has obtained, he must either prove, and the burden is on him, full, free and informed consent, alternatively, prove that it is something he was entitled to do independently of his agency, which is the Helmick case. It was an ordinary employee. It was decided in that case that even though he would have owed fiduciary duties in some respects as an employee, what he had done in that case, he was entitled to do in his own right, and he was entitled to keep the benefit.
I wonder really whether Mr. Hill's position could potentially be expressed in a different way. You get in hospital products and other cases the idea that fiduciary duties have to accommodate the contract.
Yeah.
And he says, well, this deal is such that it was always contemplated that we were going to get the benefit of goodwill, use of the name in connection with our business. So possibly what we're concerned with is not anything to do with may conflict, real possibility of conflict, or anything to do with that. The question is, along the lines of Kelly and Cooper say, do you conclude that the fiduciary obligations, if they exist, have to accommodate the contractual arrangements or the deal between the parties?
My Lord, Mr. Hill has pinned his colours to the services agreement mast, and he says that he was granted the right to use the name under the services agreement. And my Lord, I hope I've been through that point. So then he accepts he needed our permission to use the name at the outset. A permission was given. We did consent, as the judge found in fact, to a certain use, which was only during our association. To go any further than that, Mr. Hill, and the burden is on Mr. Hill, as in Hayman Joyce, to prove a contractual, a lawful entitlement, and this is the difference between a permission and an entitlement to use, a lawful entitlement to use the name in his own right. And that is precisely what we were not prepared to do at the time, did not do at the time as a matter of fact, and did not do under the services agreement.
And I follow your submissions and all of that. It doesn't seem to have much to do with fiduciary duty.
Well, my Lord, in my submission it does, because what he can, where it goes on, then it goes on, because in English law it deals with my Lord Sir Christopher Floyd's penumbra point, because as a matter of English law, with an unregistered mark, an agent could not do anything that potentially conflicted with his principal's business. So if he draws up a mark that's borderline similar for European purposes, an English court would undoubtedly say there's a potential of conflict there. You haven't proved it's got nothing to do with your agency. You did that on before it's registered, you could be restrained by a court of equity by injunction from using it in your own right. You could probably be restrained from making an application for registration if the principal didn't want you to do so. If you do make an application for registration, then you are treated at law and in equity as having done so on behalf of your principal. Now, if the agent's name ends up on the register, then the register is wrong and needs to be rectified. But in order to obtain the design and registration of a mark in his own right, the agent, qua agent, has to get beyond the penumbra. He has to say, look, this has really got nothing to do with my principal's business. I did this in my own right, for my own purposes. And I can therefore, I'm entitled to it myself. So, and we say that feeds through into the pleading. Because what we pleaded, we don't have to plead there was any breach of any fiduciary duty or there was any wrongdoing, because we're effectively adopting what was done, we're ratifying what was done. We're just saying, you are our agent. What you did on our behalf. So a court of equity supervising our relationship will assist us to make sure it's our name on the title. If that's the right phraseology for a trademark. My learned friend will deal with trademark issues. And has already done so. So that's, in my submission, is the importance of the point. It was not for us to prove, as my learned friend says, it was for us to prove a contractual term that stopped him using it. And we should therefore have pleaded a contract that included a term that he wasn't allowed to use it at the end of the association. We say, no, you have our limited permission, our limited unilateral permission, whether it's contractual, whether it was an intention to create legal relations or not. That was what was agreed. You have our consent to that extent. If you want to do anything in your own right, it's you that has got to prove the lawful basis for that. And it's for you that would have had to, as my learned friend attempted to do, and I think appreciating this, he says, well, it's under the services agreement, but it's not. And he had, and if his use is permissive, then it's very well established in equity that it's effectively nec precario. If you have a revocable permission, and I think it's in the passage in that's cited from Wadlow, cited in the Home and Joyce case, you don't obtain any title. And it may be that under a contract, certain things that an agent is going to do for their principal attract fiduciary obligations. Others don't. Bousted draws the distinction, says that if an agent is directed to do something that is specified, that can be objectively determined whether or not it has been done, then they may not be under any fiduciary obligation in respect of that thing. But if there is any, but the key element is the power or discretion to act on behalf of the principal. Which puts the principal in the vulnerable position, which brings in the equitable principles. And on any basis, as the judge said, they were, in his memorable phrase, eyes, ears, etc. We entrusted our entire business to them. So in my submission, that deals with also deals with the pleading point on the license or permission, which we deal with at paragraphs 122 and 124 our skeleton argument. And my Lord Justice Newey is entirely right when he says that the order of events was we pleaded the permission. It was for them to then prove, the burden was on them to try and prove their right, and we responded in reply. And my Lord, in any event, reference can be made to paragraph 16.0.1 of the White Book. An unpleaded point doesn't necessarily mean it can't be dealt with at trial if it's just to do so and relevant evidence is before the court. The evidence in this case dealt with and was directed at the circumstances in which LLP came to be trading as Quantum Advisory. The judge heard the evidence and he drew his conclusions, and he was perfectly entitled to do so as a matter of fact. And to the scope and extent of the permission. My lords, unless I can assist you any further on the fiduciary obligations point, my lords, I haven't gone on to the relational contracts. My lord, in my submission, it's perfectly obvious that this is a true agency because the services agreement only deals with our business. But even if it did, for the Mothue reasons, insofar as LLP was doing things for us, it still owed us an undoubted duty of loyalty, and the equitable principles that would apply to that obligation of good faith and loyalty, whether arising at law or in equity, would equally apply in those circumstances. I insist you my learned friend Ms. Simpson has further submissions.
I don't detect any questions from either side. Ms. Simpson.
My lords, I hope to be relatively brief. If I may, I'm going to make a couple of preliminary comments and then deal with the following topics. I will address my lords in relation to the independent/separate goodwill issue that my learned friend relies on, then the honest concurrent use argument. I think that wraps up pretty much all that's left on his appeal. I will then deal with certain points in reply in my appeal, subject of course to any questions that my lords may have for me as we go. So if I may start just with a couple of preliminary observations. If I may follow on from my learned friend, Mr. Adams. The learned judge, an experienced judge, had the pleadings, read and heard all the evidence in this case, read and heard all the submissions from counsel in this case, and was then satisfied that he could decide what he did, which he then delivered in a reserved judgment. My second preliminary point is that my learned friend did not go into any depth into the factual findings, but in particular he didn't go into any depth as to the commercial sense behind the arrangements, which, as my lords will have heard, was an issue before the judge. It was an issue that the judge dealt with in some detail with a thorough review of the evidence and at some length, and his conclusions, and my lords, I don't think we need to go to them, but are clearly set out in his judgment 173 to 5. And he draws conclusions, but it may be, perhaps it would be appropriate just to quickly look at some of those. So it's tab 13, my lords. And if I could ask my lords to turn to A73. And perhaps we should go to A174, paragraph 73, which is where he discusses the commercial context. And one of the points that has been made in submission in particular by my learned friend is addressed in paragraph 73b, which is this notion that it's all going to fall away and we don't need to worry about it and there's some great windfall. That's actually contrary to the finding of the learned judge in paragraph 73b, which he made on the basis of the evidence. So, my lords, I would urge you to carefully consider the paragraphs prior to that, but concluding with the commercial context, but the review of the evidence that goes through as to the judge's findings set out from paragraph 56 onwards, in which he makes very clear findings, in particular in relation to the cross-examination in this case. And as I know my lords are very well aware, in the line of case law going on from Volpe and Volpe onwards, it is a very high bar to overturn such findings. And in my respectful submission, my learned friend has got nowhere near that. So turning now, if I may, to the independent stroke separate goodwill issue. Now the first point, which is important here, is that LLP, and indeed my learned friend before my lords today, has accepted first that Quad was a senior user of the mark. Indeed, it had a successful business. And it also recognised that it needed permission in order to use the mark. It could not just go out there, slap it on anything, and go free. It knew that it required permission, and indeed they've pleaded that they needed permission. They've not explained why that permission should fall away. And my lords, I would draw and urge to your attention that, of course, at no point did Quad itself stop using the trademarks and branding as it evolved from time to time, up to and including now. Because via the services agreement, acting on Quad's behalf, those brands and marks have all been used. And my lords, I would draw also to your attention that that includes, for 2 years prior to the filing date of the trademarks, the Hero Q and all the other marks are subject to the application. And that, in my respectful submission, is important going to my lord, Sir Christopher Floyd's point earlier about timing of use. Now, the other important matter on the facts, and some of those facts, my lords, I have shown you, is that LLP has never presented itself as some sort of separate entity. Far from it. It has relied on and built on the heritage from 2000 that was Quad's. And that was indeed in the background of the reasons for entering into the agreement. It was a reason for entering into the organisation whereby they could use the mark, both the Quad's business and were given and had permission to use it in respect of theirs. And it can be seen from looking at the letterheads that my lords saw yesterday. It can be seen from the fact that the website was used from time to time, presented in one seamless form, with, as the judge found, with testimonials dated back to 2000, on that website. And far from being independent, it was linking itself, as in Dawny Day, fully into the Quad heritage. And that was what was intended. And so, in my respectful submission, this is not a case where it can be said that there is some sort of independent or separate goodwill that's created. They had a permission, and they've used pursuant to that permission, and we've at all times accepted that while the services agreement is in force, that permission continues. But what they didn't get was the mark and the right to use the mark on its own for their own purposes after the end of the agreement. Now, my learned friend relies, or has referred to briefly, to Scandicor in relation to his case on independent separate goodwill. Now, my lords need to be very careful because the judgment that is in the bundles is the Court of Appeal. In fact, Scandicor went, as my lord, Sir Christopher Floyd, is probably well aware, went to the Supreme Court, whereupon the Supreme Court made a reference to the CJEU, at which point the case settled. And the points on which the Supreme Court were concerns in relation to licensing and the like. So I would, in my respectful submission, Scandicor should be put to one side, in the sense of how my friend seeks to rely on it. But in any event, the facts there were entirely different. It was not a case which involved two parties having businesses both in the United Kingdom. It was a case of a foreign company trying to assert that it had a goodwill in the United Kingdom via a license. So in my respectful submission, it's Scandicor should be put to one side.
We're bound by the Court of Appeal's judgment in those circumstances, aren't we? We can't just disregard it.
Well,
that would be my first response to you. But secondly, what Mr. Hill gets out of Scandicor is that the goodwill belongs to those who are responsible for the products or services, subject to any agreement between the parties to the contrary, so that that prima facie position can be displaced by contract. Is that something you say is wrong or shouldn't?
Well, my lord, I actually said the position is, as described by, as my lord picked up in Wadlow, that where there's a permission, where there's a license, then it goes back to the
You
license.
say there is a license, the collateral license, which the judge found.
Yeah.
So why should we put Scandicor in the bin?
Well, it's very peculiar on its facts.
Well, maybe, but that principle seems to me to be quite a comprehensible principle, which is not necessarily inimical to your case.
No, it's not necessarily, but as I say, that the question of whether they were in that case in Scandicor, there was a question as to whether the use in the United Kingdom was in fact used by the.
I don't think Mr. Hill was urging us to say that it was an identical case on the fact.
As I say, in the present case, we said there was a permission, and therefore it doesn't arise. It was very different. It is different facts, and there is a relationship between the parties. They're not independent. In Scandicor, there was a separation than the previous.
Yes, different facts, but the principle is that which I've expressed, and seems to me that you pray that in aid rather than disregard it.
Yes, when I say be careful with it, it's the Supreme Court did give a judgment before they made a reference, and obviously, and including in Amanda Michael's case, she does talk about, and in fact, the judge in this case said you need to look at the facts of the case. So I would accept that you need to look at the facts of the case on the ground, and I would say that in the present case, one looks at the position as in Dawny Day, which the judge did in this case, and apply that approach. So yes, I mean, I do, in the sense that my lord is saying, if there was no agreement, is it possible? Well, if there'd been no agreement, my clients would have sued them, and according to their own case, we would have won, because he's accepted that he needed permission.
So follow that. I was just
Yes.
wondering why we should not pay attention to scandal court, which seems to be set out quite a clear and useful principle.
As I say, my lord, I've just wanted to draw to your attention that this did go to the Supreme Court, and there is an issue.
They didn't say it. No one said it's wrong.
I suspect the way they said it's wrong is it's wrong on the facts, but not maybe in that particular regard. So, my lords, in this case, the learned judge set out and structured his judgment, recognising the approach taken from the Dorney Day case. And in my respectful submission, he was entirely right to do that, and it was entirely within his remit, if I can put it like that, to do that. And I've not heard from Mr. Hill to say that Dorney Day and the approach in Dorney Day is wrong. We say that the judge recognised the appropriateness of applying Dorney Day and set it out very clearly at A164 to 166, and they cannot say that he was wrong to do that. Perhaps going to my lord, Sir Christopher Floyd's point again, in the Heyman-Joyce case, which is at AB2 tab 26. Now we have been here and there, and my learned friend has explained to you the background facts, and I think this goes to my lord Sir Christopher Floyd's point, is at head note finding 1 on page 545. The ownership of goodwill depends on the individual facts of the case, and in this case on the contractual arrangements between them. So that I think goes to my lord's point. That can be found in the judgment at paragraph 31 at page 556. And my lords will have seen the citation. And again, I think I'm agreeing with you, my lord, Sir Christopher Floyd, that it all depends on the facts of the case. Now, turning into the judgment, my lords have been taken to this, but I think it is important to have in mind paragraphs 43 and 44 of the judgment of Ms. Michaels sitting in the Intellectual Property Enterprise Court. Because in my respectful submission, the judge has carefully set out the position and in a way, and the statements of principle with which we would agree. And therefore, in my respectful submission, this case does not take my learned friend any further forward, because on the facts of this case, and applying the approach recognised by Ms. Michaels in this case, the result the judge's judgment should be upheld. There is nothing to say that it was wrong. Now, the related but nonetheless different case that is put forward by my learned friend is that of honest concurrent use or some sort of concurrent goodwill. And he praised in aid the Budweiser cases in his skeleton of argument, and he took my lords to must-match case this morning. Now, the very important thing to appreciate with honest concurrent concurrent use, and in particularly the Budweiser case, and I think it would be necessary to go to those cases, is that we're talking, in those cases of honest concurrent use, they are independent parties. One of the many things that these parties in the present case can't be described as is people who are independent and knew nothing about each other. They've had a commercial relationship. And in Budweiser, it is, of course, a very particular case. Now, if I could ask my lords to take Authorities Bundle 1, tab 16, is the judgment of the CJEU, and it's followed by the judgments of the Court of Appeal when it came back to the court in this jurisdiction. Now, the case arose in the context of invalidity proceedings as part of a very long-running battle between what I would call the American company and the Czech company that both sold beer under the mark Budweiser. There had previously been an action where each party had sued the other for passing off, and those actions were dismissed on the basis that neither side was making a misrepresentation. Now, the issue arose, one of the issues that arose for determination in the subsequent proceedings was whether honest concurrent use could provide an answer to a claim for an invalidity objection on the basis of an identical mark in respect of identical goods. Now, the important thing to understand here was that the marks had both parties had a trademark. They had slightly different dates for filing. Now, the first point to notice is that it was a case about two independent parties who had independently adopted, I should say, and used the relevant mark. And they lived side by side together. And we can see that at page 378. The judgment in this case starts on page 376. The questions referred can be found in paragraphs 9 and 10 at the bottom of 377 over to 378. But one can see, as part of the factual matrix at 10, I apologize, the questions are later on, the factual matrix is set up, but one can see at paragraph 10 that the order for us states, although the names are the same, the Budweiser and Anheuser-Busch beers are not the same. Their taste, prices, and get-ups have always been different, and in markets where Budweiser and Anheuser-Busch coexist, consumers are well aware of the difference, although there will always be a small level of confusion between them. Now, there was no issue whatsoever of any consent one way or the other, and consent of use is different from acquiescence, and we can see that from paragraph 43. And as I say, in this case, LLP concede that they needed permission when they started doing the acts that they now claim are honest concurrent use. And the other important thing to note is that obviously in the Budweiser case, it was an exceptional case, and that's recognised in paragraph 76 of the judgment. The answer to the question is at the end on page 387. And in my respectful submission, this is very far from the case we have here, particularly when we go on to look at, which is behind the next tab, what the Court of Appeal said when the case came back to the United Kingdom.
So, sorry, where were you just taking us for the answer to the case?
The answer to the question is on the last page, which is page 387 in the bundle, and you see little 3.
Yes, I see.
Now, if I could ask my lords to turn over the page to the next tab, you find that here the Court of Appeal, once it had come back from Europe, if I could perhaps ask to have a look at just at the head note 1, just to give a context of the background to the case. And in looking at the holdings, the relevant ones, I think, for these purposes are at page 390 to 391, which is 2 to 4. Now, if I could ask my lords to turn into page 395 at paragraph 17, one gets the finding that about the brands having lived side by side for many years. And paragraphs 19 through to 23, which speak in terms of how this is an exceptional case. Now, the important point here is that there was no senior user in the Budweiser case. Here, Quantum Advisory did denote, as is admitted, a single company. That's Quad. And the guarantee in this case is also different. On the facts, the use has been to present the public services under one brand, a brand which has evolved over time. That brand signifying a business as having a connection with the business of Quad. Hence the testimonials, the reference to business being carried out since 2000. A position that was emphasised by the judge in his paragraph 15 of his judgment. And as I've submitted already, the use by LLP was with consent. Even on LLP's case, it needed permission to use the mark at the outset. So that it is simply not supported in the evidence that LLP thought that it could go out and just do what it wanted with this mark. And in my respectful submission, the fact that it knew that it was time limited to the extent of the services agreement is confirmed by the fact, on the evidence, which is not challenged, that the domain name would have to be given back when the services agreement came to an end. In this modern day and age, which person would party would hand over the domain name at the end of a services agreement if it thought that it was entitled to continue to use the name? And it's also important to have in mind, in this context, that these proceedings came about because LLP threatened Quad with infringement, i.e. it assumed for itself exactly the points that I first took my lords to as to what is a trademark and what it gives you. It was taking for itself a right to exclude all comers, including Quad. So in my respectful submission, the case on honest concurrent use is simply not made out. Now, turning to the question of my appeal, if I could just run through the points. As my lords may recollect, Article 10b is set out in the Act. It's not, although for convenience, parties have been breaking down the provision into constituent parts. It could be said to be, in fact, more holistic than that. But it's important, my lords, to look at the wording just for a moment. And the wording of the Act can either be found in the judgment or in Authorities Bundle 1, tab 4, page 51. Now, and my lords will see there, subsection 2 applies where a trademark is registered in the name of an agent or representative of a person who is the proprietor of the trademark without his consent. Now, one point that it occurs to me, which I thought it would be useful to clarify, in fact, in the light of some of the questions from my Lord Justice Newey, is to say that you can have one trademark, say for Coca-Cola, but there are two routes to protection. So Coca-Cola may be protected by trademark registration, or it may be protected by way of an action for passing off. So it's the same trademark, but there are two routes to protect it. And as my Lord Justice Sir Christopher Floyd will certainly be very familiar, it is very common in an infringement action for a party to sue for trademark infringement and passing off. And it's for that very reason. It's all the same mark. One is registered, one is being protected by way of a passing off. And that was just to clarify that point. So proprietor of a mark. Going through the next point on this is when one looks at the provision, the one thing that comes out of here is there is no reference to similarity in this provision. So one's got to be very careful in sort of trying to effectively say write similarity into this provision. It isn't there. So in my respectful submission, one's got to think about the purpose of the provision when taking into account what's covered. And there are 2 points to make on this. First of all, as my Lord Sir Christopher Floyd made clear yesterday, I have now been, my client's quad has now been held to be the proprietor of 3 marks. And the Quantum Advisory mark is in fact the latest of the ones filed. The other 3 marks were all filed on the same day. But as I've just explained to my lords, they were all in use, both with respect to Quad's business and with respect to LLP's business, for at least 2 years prior to the application being made. And my learned friend this morning admitted that the Hero Q device was similar to the 2 marks that were filed on the same day. So I would mention that, although I don't accept that the word similar is written into the statute. But what I would say here is, the test is this. You've got a business which is operating, it is using branding. And if I could respectfully ask the court to consider this question. Without the other marks, Quantum Advisory and those other 3 marks that are now, it's now been held that that my Quad is the proprietor of, would the Q mark ever exist? Would it have ever existed? Why would you have applied for it? You wouldn't apply for it on his own. And it's, my lords, this is to illustrate the symbiotic nature or interlinked relationship between the marks that are before you. So, my lords, that brings me to the subsection 2 of 10b, which is the justification. Now, my lords, we've spoken in terms of, as I said, we spoke at length about the proprietor and how proprietor, one can look to English law to see title. I'm not going to go through all of that again. But when thinking, with my respectful submission, and as in fact my learned friend made clear today, justification may involve concepts of English law, because, as he says, he would rely on honest concurrent use as his justification for filing this trademark. So, my lord, whilst we're given a route map or a procedure as described in the Ricketts book that I took you to, section 10b, Article 13, give you a procedure, they don't tell you how to apply it. But one shouldn't think of it as only at the front end. The bit that comes in, it is accepted, it applies when there are agents and representatives as defined. That is a European concept. But when one is looking at when one's looking at the justification and who has title, elements of national law obviously creep in. They must do. And indeed, my learned friend, in seeking, as I say, to rely on Croom's trademark and concepts of equity allowing him to justify his registration, proves my point.
I think he now accepts that national law governs who the proprietor of the mark is.
Yes, I believe he does, but I'm saying it's not just as simple as that, because as proved by the justification.
Well, I'm sure you can make it more complicated, but for my purposes, it's enough.
Right. Anyway, the point is, my learned friend seeks to his justification is based in part on a principle concept of honest use. In my respectful submission, the findings of the court that there is a consent that only lasts a particular length of time, permission, precludes an application for a trademark in his name. It cannot be justified for the reasons the judge said. And the reason, and part of this is, unlike what my learned friend has said, it is not right to say that LLP is not, the quad is not prejudiced by the filing of these applications. That is simply not right. First of all, we don't know, if we assume that a trademark could be registered, and there is uncertainty about whether a trademark could be registered by my clients, unless, obviously, with LLP's consent, that may be possible, but the registrar may raise objections. So, but assume that it's allowed on. First of all, for all the reasons, the dates would be later for the trademark application. So it would have a later date than the dates acquired by my learned friend clients, because it would only be now. And the other point is, there's a real risk that LLP can deal with the mark as it likes. It's got these trademarks, it could license it to whoever it wanted. There's nothing to stop it, according to their position. They could license it to 15 other companies. There'd be no reason why not.
Aren't you prejudiced simply because it would provide them with a defence to an action in passing off?
Well, it's subject to us being able to take steps. Well, they could try and rely on it in respect of an action for passing off, but a trademark, but a passing off will not necessarily be defeated by a trademark registration. It's separate. As my lord's aware, nothing in the Trademarks Act prejudices a claim for passing off. So whilst it is true that in a trademark infringement action, their earlier trademark would be a defence under the Act, it's not right to say that it would be a defence. I mean, according to their case, they would have other defences. But obviously, we accept that there's no case for us to bring a passing off claim whilst the services agreement is in force. So we are prejudiced because they could license other people, they could sell the mark, they could assign it to someone else. As I think, and I forget whether it was, I think it was my Lord Justice Newey who suggested if they went into liquidation, or perhaps it was my Lord Justice Nugee, it could end up with a liquidator. And in all those scenarios, it cannot be said that my client is not prejudiced by the registrations of these trademarks. But of course, we say we don't get that far because we say that on the findings of the judge, for all the reasons we've discussed, LLP is not the proprietor in any event. My lords, unless you have any further questions.
Don't detect any, so thank you very much, Ms. Hinsworth. Mr. Hill, you have the last word on your appeal.
Yes. So, if I could just reply on my appeal. So we say that the services agreement does not need to be supplemented with a collateral agreement regarding the LLP's business. Contrary to what my learned friend Mr. Adams said, the fact that it doesn't say that much about the LLP's business in terms of sheer number of clauses doesn't really tell you anything. One wouldn't expect it to say very much, but it says enough. It has within it the broad requirement that the LLP does not prejudice Quad or bring it into disrepute, clause 8.5. That is obviously governs the LLP's actions generally. There is also the requirement for the alignment of services, which is what the judge referred to in his judgment. But then as regards the making available of assets clause, that one must bear in mind there is also clause 16.2, which is on page A223. You may not have looked at this clause before, but this is a clause which, upon termination, requires a payment, requires the provision of assets up to a certain value. And that clause is there to reflect essentially the wastage of assets passed over under the agreement. So obviously stationery and chairs and tables and things like that will have been used up. So instead, some money, assets to a certain value have to be handed over. And that sits well with what we say is in any case apparent from the making available clause, which is it's an unfettered making available, subject only to the requirement that you do not bring Quad into disrepute or prejudice it. And that is plainly what the parties agreed. And for the judge to think, well, there was a special agreement relating to the name or to the goodwill, we say doesn't make any sense because obviously other assets were being passed over and were to be used freely by the LLP, such as physical assets, the domain name, etc. But there's no suggestion of any agreement relating to them. So all that needed to be given was we hand them over to you. Nothing more needed to be said. There was no fetter on the use of them, and that's the way it stood. So we say there's no need for a separate license, and when really you only get a separate license into the realms of discussing that if you want to reach the conclusion that Quad keeps the LLP goodwill. So that really works backwards from the conclusion. It's an endpoint which we say that on the factual circumstances would have to be agreed, but no agreement to that effect was pleaded or was it shown. And if you think about whether the judge approached this question of agreement in that part of his judgment, he's concluded that an agreement has been concluded while the parties are still hard in discussions regarding their ongoing relationship, which is an inherently unlikely proposition. Why would you finalise your agreement when you don't know what the ongoing deal is going to be? And when one actually looks at the evidence cited by the judge, so paragraph 62 is particularly relevant, and he cites some of Mr. Baldwin's evidence there, and I think this is the only place where one can actually see in the evidence any reference to something being agreed. But in the second part of the quote, you'll see, first of all, there's an informal meeting discussed, and there was a potential loss of business and disruption and damage to the brand that would ensue to the LB if it lost the business. So that is not a conclusion that it was agreed that it would lose the business and brand. And then he expressly says we didn't come to any conclusions at that meeting, other than that it needed to be addressed. And then this is where the one mention of agreement is they agreed the extension of the term as a way of dealing with the issues. It doesn't say how it dealt with them. It doesn't say, well, we accepted that it was a term that goodwill would inure to, the LLP business would inure to Quad. It doesn't go into that at all. And what it's actually talking about there, I would submit, is very clearly discussions within an overall discussion progressing towards a formal agreement, where parties were proposing things and it was accepted as part of the negotiations. They moved on and then they finally reached agreement. And then nothing else in this long extended passage of evidence actually reflects any agreement. And when we get to the end of it, in paragraph 68, 69, the judge finds that, finding the fact that this was the express basis on which the use of the mark was agreed in 2007, but he doesn't say when, where, what were the words by which it was agreed, which we would submit is something of a pointer to the fact that this wasn't properly pleaded and that the evidence actually doesn't sustain where the judge was going. Anyway, no doubt your lordships will have the opportunity to read those paragraphs in preparing your judgments, and I would submit that there is nothing related. There's no express term. It doesn't say here are the words where the parties agreed, and that really undercuts the conclusion the judge drew. I think the way we would put it is he sort of saw a solution which unfortunately was not open to him, and either on pleadings or all the evidence. And so one comes back then to the approach which was discussed by my learned friend, the Scandicourt approach, which is what is the factual basis for where the trade origin is, and then is there an agreement to displace that? And we don't get an agreement to displace it, because if we're in the services agreement, there's nothing there. You can use this. To get away from that, one has to imply something. One has to have a basis, a legal basis for implication. And for the reasons I outlined in opening, we say there isn't one. It's not a case where Marks and Spencer could come to one's assistance. In fact, everyone on the LLP would be saying if you had a debate about it, including the 99-year term, avoided the debate. But if you had a debate about what term one should have as to where the goodwill is at the end, it would be one where reasonable people could disagree. I would also draw the court's attention to the fact that if one looks at the Q, the hero Q, of course that isn't something which was in existence at the beginning of the agreement. So there could be no question of any license being granted in relation to the hero Q at the outset. The hero Q has to fall within assets created by the LLP during the agreement and fall squarely then within the regime of the exit provisions. can't be a quad asset which is there at the beginning and has to be returned. Now, on agency, I don't think I really need to say very much. Our main point is that this relationship is conditioned by the agreement. It sort of merges in the agreement, which will govern how it should be treated. And one can't boost that by saying, here's an agent. And in fact, it would be inimical, we say, to what the parties agreed and to the end point that the parties expected, which was that the agreement would carry on to the end. But I'll just point you back to that quote from Mr. Baldwin, that's in paragraph 62, page 169. But you see there, he doesn't mention at all any considerations of early termination. That wasn't the driver. It was that there's a 10-year period at the present time. And that's when the worry is going to come, and that we can deal with that through a longer term. Now, if I could just move on then to my own friend Ms. Hinsworth's submissions. So first she made some preliminary points about how the judge reached his decision based on what he'd heard at trial. Obviously he had. That doesn't preclude a judge from going wrong. And so I don't think that gives you any guidance as to the outcome of the appeal. As for the factual findings, I've dealt with those just briefly just now. But in terms of the commercial sense, we say that what the judge said there, on pages A174, paragraph 73b, as regards the falling away of the goodwill, he doesn't actually there deal with the position. What he says is, well, actually, the business has grown now, but what was accepted in the evidence of Mr. Coombs was that it was anticipated, when the parties were discussing things, it was anticipated that the business would ebb away, which was obviously a completely rational approach. And one has to look at the underlying substance of the deal. Essentially, people who are only concerned with quad are moving off the scene. That was the nature of the deal. All of its assets are going away. It's going to have some duties, such as the duty to put up prices, to do tendering, but it's very much leaving as a substantial player in the actuarial business and passing that over to be conducted in relation to legacy business by LLP under the terms of the agreement, and for all future development to be conducted by the LLP on its own account. And that is the relevant context, we say. This is a case where someone essentially wants out and they need to be compensated for it. They're obviously not thinking about what's going to happen from their perspective in 99 years' time and thinking, well, I'm a quad person, I want to be making money at the end of it. That's something which will affect the people who have the ongoing contracts of the business. As for the independent separate goodwill point, our first point is, well, it's not really about permission in this case. It's about who owns the goodwill. Do we have a separate goodwill? Does my client have a separate goodwill which it should be entitled to protect? Whether a permission would be needed in any particular factual circumstance on the end of the services agreement would depend. We say now the LLP has established a substantial enough separate business of its own. It wouldn't need permission, but at some earlier points it might have done. But that doesn't need to trouble the court, because the question is there this valid separate goodwill, and is that something which it can protect, my client can protect legitimately through a trademark on its own account? Now, as regards the presentation of the LLP as separate, of course it's the case beginning it was presenting itself as linked. That was the very purpose of the deal. But the point is that factually underlying that, there was no connection to court in relation to the LLP business. Factually, the person responsible for those services is the LLP. So one applies Scandical, and one then has to find your contractual term, passing goodwill arising at that point in time, over to court. And we say one can't do that. The Dorney Day case does not assist, because the Dorney Day case is an application of the principles of implication of terms to the facts of that case. And they are sufficiently different from this case that one can't simply move through and arrive at the same result. Now, in the Heyman-Joyce case, I don't need to say much more about it than what I said in advance, but I would question what my learned friend said about it. It said about honest concurrent use only relating to independent parties, because the Heyman-Joyce case is a case where the parties were not originally independent. So I would say my submission is that there doesn't need to necessarily be independence of parties for honest concurrent use to arise. That may well, that's a category of such cases, but it's not all of them. And also, I would also say that the Ideal Home case and the match and must-match cases show that honest concurrent use is not, although it's called exceptional in that case, it does arise, and it arises in quite a large number of separate circumstances. If you look at the must-match case and the Ideal Home case, again, one can also see there's no requirement of senior user. The junior user can be entitled to, well, often will be. It's not a question of who comes first when one has honest concurrent use. And so that again is not a ground on which my client can be disentitled from relying upon the principle. Now, my learned friend also suggested that throughout the arrangements, the LLP knew that its right to use the goodwill was time limited. In my submission, that's not founded on the facts. There is no specific finding anywhere that was known. There is mention that there's a risk of having to lose the right to carry on at the end of the 10-year period. But that doesn't take you to any conclusion that the LLP knew that at the end of the arrangements, at the end of 99 years, it would have to stop. And in fact, as the factless appeal is before the court shows, the analysis of these type of arrangements, what their legal ramifications are, is extremely complicated. It's not something an ordinary layperson would know, nor would they make assumptions about it. And the qualified email from Mr. Reed Jones at the time about the risk is as far as any layperson would be likely to go. And I think probably the last point I need to deal with is just the question of prejudice. And we do, ultimately what my learned friend was saying about prejudice, we say boils down to the fact that there is prejudice, they say, in there being an independent goodwill. But that is in fact what was agreed. So if we're right that my party, the LLP, was entitled to an independent goodwill, that isn't something that can be separately complained of. If we're wrong about it, of course, then indeed a complaint can be made, but then the appeal will fail anyway. So I think I've dealt with everything I need to. So unless you have any questions.
No, I don't think so. Thank you very much. Thank you very much to all of you for your submissions. Thank you very much. 2 for coming in on time, even though we lost time yesterday, which makes life a lot easier. We will, of course, be reserving the judgments. You will, in accordance with normal practice, receive them in draft in advance of their being handed down. And at that stage, we'd be grateful for comments on our typing in English, but not, of course, comments seeking to re-argue the issues. We'd also be grateful if, in advance of the hand down, you would seek to agree an order dealing with consequential points. If there are points on which you disagree, could we please have brief written submissions, and we would expect to address them in the order that we make. Lastly, as I'm sure you're all extremely well aware, there has been concern in this court in particular over compliance with the embargo. I think you've supplied lists of email addresses to which the draft should be sent, but I would just remind you of the importance of complying with the embargo. But thank you all very much for your very interesting submissions.